Peter Wright has worked as a solicitor and advised clients on data protection for more than a decade. He's the managing director at Digital Law, where he and his team advise clients from around the world on data protection, GDPR, and cybersecurity compliance, along with social media law, e-commerce, website compliance, software licensing, privacy, and Freedom of Information Act matters. He's also the chair of the GDPR Working Group of the Law Society of England and Wales, a member of the Law Society Board, and a past chair of the Technology and Law Reference Group. Join Peter now as he reinterprets the meaning of privacy in the context of technology, social media, big data, and elections.
Hello everyone, and welcome to this session, which I've titled Through the Looking Glass. My name's Peter Wright. I'm a solicitor, which means I'm a lawyer in England and Wales. I'm also chair of the GDPR Working Group for the Law Society of England and Wales, member of the Law Society's Council and Board, and also chair of their Policy and Regulatory Affairs Committee, which means that I end up dealing with a load of different issues related to legal policy on a regular basis, and in particular, issues with regards to privacy, data protection and security. And that's what I deal with in terms of my daily practice. I run a law firm, Digital Law, and we do a lot of advising clients all around the world with regards to everything from e-commerce to data protection, cybersecurity, privacy, and the general sale of goods and services online in different jurisdictions. And what I wanted to do today was actually take you through a few observations with regards to the development of privacy, before then applying that to the way that our technology is developing and our general direction of travel overall. So in terms of what we'll start to look at today, we'll indeed look at that background in terms of the development of privacy. I'm going to look a little bit at elections, but I'm not going to be drawing some of the conclusions that you might have expected. And then we'll try and extrapolate that in terms of where we go in the future. But I wanted to start off actually just by looking at some context. Where does our concept of privacy come from? It's becoming an important concept that we see in the news almost on a daily basis in terms of the expectation that people have in relation to privacy, in particular online. But speak to anyone, and very often they'll have differing perceptions of what that right of privacy actually is. And let's try and get an idea of where it comes from overall. So in terms of the definition of privacy, the idea of the state being apart from other people or concealed from their view, solitude and seclusion, i.e. having that right of privacy away from others. The idea of the state of being totally free from unwanted intrusion, freedom from publicity, freedom from public scrutiny or surveillance or unauthorized disclosure of your data. It's that element of secrecy. And very often people think we have this automatic right to that when we are online, and indeed when we have it in our day-to-day lives. But an expectation of privacy can often vary from country to country, let alone when we start looking at the expectation of different citizens in different countries when they are online. Let's actually have a think about the evolution of privacy overall. And I think we can probably trace it back to the 1890s. We can look at two US lawyers, Samuel Warren and Louis Brandeis, who wrote The Right to Privacy, an article that actually set out the right to be left alone, using the phrase as a definition of privacy, starting off that initial concept. Then we start to look at the development of privacy in jurisprudence as a whole. We have the Universal Declaration of Human Rights, 1948, which talks about the right to privacy for the first time, including it as one of those 12 fundamental rights. Then fast forward a few years, we get the EU Convention on Human Rights, sequencing fundamental rights with articles in a slightly different order, but making it clear that these now apply with regards to the continent of Europe. Fast forward a few more years, we have the first Freedom of Information Act coming in the United States, giving everyone the right to request documents from state agencies. Other countries follow suit. In some instances, it took decades. for Freedom of Information Acts to be introduced in different countries around the world. Some still don't have them. Others have freedom of information with varying degrees of success. Indeed, some may argue that the right to that information varies significantly from country to country. Then fast forward again to the 1980. The OECD issued guidelines on data protection, with one eye on the increasing use of computers to process business transactions. 1981, we get the Council of Europe looking at a data protection convention, rendering the right to privacy a legal imperative. 1983, the Federal Constitutional Court of Germany reaches a fundamental decision regarding census judgment, and this is seen as a milestone of data protection. Just 1 year after that, we get the UK Data Protection Act 1984 being introduced here in the UK. 1993, PC Brown is charged under that act for an offence of using personal data for a purpose other than that described in the Data Protection Register, a key principle saying that personal data can only be used for certain specific acts and should not be abused. We then get the first element of pan-European data protection regulation with the European Data Protection Directive of 1995. This, of course, as a directive means it doesn't take direct effect across the European Union. Rather, individual nation states are then left to introduce their own versions of data protection law. And, surprise, surprise, data protection law is implemented across those EU member states with varying degrees of success. We got the Data Protection Act 1998 in the UK, which introduced the regime that then stayed in place in the UK all the way through until the 2018 Data Protection Act was eventually introduced. Meanwhile, in some of the federal German states, we had a much stricter version of data protection legislation introduced. And indeed, data protection regulators were then established that all took varying degrees of enforcement action against those who had carried out breaches of that data protection legislation. Key principles were set out. Which data should we actually class as being sensitive? And also established the need for consent in certain instances with regards to different processing actions. 2002, we then got the Privacy and Electronic Communications regulations, which ended up then being introduced across the EU as well. We then got the EU directive on the retention of data generated or processed in connection with the provision of publicly available electronic communication services or of public communications. And this was adopted in 2006, but it was declared invalid by the Court of Justice in 2014 because it was felt to violate some of those fundamental rights that we referred to earlier on. 2009, evolution of the EU electronic communications regulations in response to the growing use of email addresses and mobile phone numbers becoming freely used by marketing agencies and in sales campaigns. The international non-profit organization WikiLeaks then started to publish secret information in 2010, leaks of sometimes classified information provided by anonymous sources, and indeed that started to publish information from a variety of different governments, some of which was very sensitive information that started to contribute to some of the geopolitical events that then happened through the subsequent decade. Meanwhile, the European Commission adopted its regulation in 2013, 611/2013, on measures applicable to the notification of personal data protection breaches. We then get in 2014 the introduction of the right to be forgotten, following a ruling with regards to an individual who was quite frankly fed up of seeing reference to his mortgage having been defaulted some years before. The fact that kept being revealed when everyone did a Google search of his name meant the individual ended up going to the European Court ultimately to have that information taken down, and hence the concept of the right to be forgotten ended up being given birth to and was then incorporated into the General Data Protection Regulation of 2016, which wasn't actually as radical a step as many people felt that it was. It was, in fact, a fairly reasoned, logical extension of a lot of the rights originally contained in that Data Protection Directive from 1995. It merely drew together an awful lot of those rights and then incrementally added to them. In the UK, we then got our Data Protection Act 2018 that not only incorporated GDPR, but ended up making it clear what derogations would be applied as well. And this is quite a key thing. Everyone tends to think that GDPR now applies uniformly across the EU, when it doesn't. There are significant derogations. The definition of a child varies in different nation states across the EU. The methods of enforcement vary. And therefore, even though the UK is now outside of the European Union, even within the EU, the way in which GDPR is enforced and the way its laws are applied does vary significantly. So it is not as entirely uniform as many at first presume. And then, of course, we start to get the evolution with regards to even more personal data being gathered through various different technologies, different levels of IT governance, and hence GDPR already is, to a certain extent, being seen as obsolete. Indeed, recently in the German parliament, the point was made that GDPR does not necessarily take into account the such rapid development of technologies such as artificial intelligence and blockchain, and therefore already potential updates are being considered when it comes to GDPR and its future use. So let's, having looked at that whistle-stop tour through the history of data protection and privacy, let's instead start looking a little bit at wider societal privacy. Everyone used to know everything about everyone else if we consider the general evolution of people's privacy. Very often when people, before the Industrial Revolution in different communities, before technology came along, all people had to talk about was what other people were doing. Hence, gossip developed. Everyone knew everyone else's business. Everyone very often shared, due to the general levels of poverty several hundred years ago, everyone would share what property that they had. Therefore, gossip would very often spread very quickly among different communities, potentially overnight. And sometimes that gossip could be true, it could be untrue. But sometimes whatever was shared and what people thought would end up becoming established fact, while in the meantime, the truth was still putting its shoes on, as it were. This ended up being the case as well when technology starts coming along. People move to the cities, the phone starts being used. Yet in many communities, party lines were common. This was where different phone lines would end up being shared by different households and different individuals. So it was very common, in fact, that many people's first experience of a phone call wouldn't be a phone call from one individual to another individual. Instead, it would be more like what we would now call a conference call, with lots of different people being at one end of the phone line and lots of people at the other, and they would all listen in along with everyone else. So one person might have a conversation with one individual, everyone else would listen, then it would finish, then it would be time for someone else to say something. Hence, this was very common. It was only later on that people started necessarily paying for their own private lines. And certainly in the United States, it was legal for law enforcement agencies to listen in on these party lines. There was no expectation of privacy, no warrant was required. With the Universal Declaration of Human Rights post-war, this was then the first time that people started to consider this element of privacy with that 12th fundamental right. And this ended up being adopted by the UN General Assembly. So we then start to get a level of government interference with regards to our personal lives. Think about the massive expansion of this just over the course of the last 12 months with regards to the global pandemic. Far more information is now being collected on individuals on a regular basis. This was very much increasing with everything from the provision of different public services, the emptying of bins, the provision of medical services, the collection of tax. All of these things are different touch points that give the state overall greater access to our personal data. And then we have the expansion of that within the last 12 months. Things like track and trace. In the UK, this has meant that if you end up walking into a pub when they're actually open, you would have to say, who were you there with? You would have to provide your contact information. You would have to potentially the records of any transaction that you had, confirming what food you had and what you had to drink would also be available. This information would then be retained by the establishment, wherever it was you had gone in to purchase goods and services. That would then be kept for at least 14 days and could then be acquired by the state as they then look to see if there had been any infections that ended up being passed on as a result of your visit to that location. And we end up looking at this balance between security, necessity, safety, and health versus privacy. Before COVID came along, of course, one of the big drivers behind the state collecting more information and generally keeping a closer eye on different communications has ended up being security, the need to keep us safe in view of the ever-growing threat in terms of terrorism, in terms of fraud, and in terms of the proliferation of criminal activity. And there has always been a fear of misuse with regards to how this data is collected. But we have to ask ourselves, when governments end up introducing these laws in relation to data protection and privacy laws, will they end up therefore breaking those laws? In many countries, it's the case that these laws are introduced and then the government will try and be as transparent as possible with regards to the instances of when those laws might end up needing to be contravened and stating why that might be the case and what the reasons might be. Whereas in some other jurisdictions, sometimes that transparency is not there or is not felt to be there. But certainly with regards to the increasing frequency of the way that governments end up collecting data on us, it's meant that certain older established norms have ended up then potentially being brought into question. Every 10 years for over a century, many Western governments have ended up holding censuses every 10 years to allow them to work out what is the pull on public services, what do we have to plan for, where should we be building schools, where should we be building houses, how should we be developing cities, what population trends and demographic changes do we need to be mindful of when we are continuing to develop a country. These decisions very often used to be severely led by the patterns and the data captured in that 10-year census, when that large amount of information would be returned by every single household, in theory, in a country to provide the government with that access to the data that it needed. But arguably when governments are now collecting so much data on a daily basis, do they necessarily need to carry out that census? Do they need not just to justify the expense and the draw on everyone's time to go through that, when arguably they're getting just as much rich data almost in real time on a regular basis? So is there therefore the need to carry on with the census? And this has been a real touch point in 2021, certainly in the UK. We are due to be having a census this year, and with the potential risk of transmission of the virus, of people going door to door handing out these questionnaires, or then people completing the questionnaires and filing them back, there is the potential there for there to have been a potential transmission vector for the virus. And that, along with concerns generally with regards to, does the government really need to have this additional channel of collecting of data when it already has a significant number of sources of data available to it, has meant there's probably been a bigger challenge this year to the carrying out of a census than there has ever been before. But still, at the moment, that census is likely to be pressing ahead. So let's look a little bit wider in terms of privacy worldwide. Last August, we saw the second decision of the European Court involving Max Schrems. Max Schrems is the Austrian law student who famously took Facebook to court in 2015, ultimately going all the way to the European Court of Justice with regards to the data that Facebook was maintaining, processing on him. He had basically carried out a subject access request. He wasn't happy with the data that ended up being returned to him, questioning the way that Facebook was collecting this data, questioning the transparency, questioning the fact this data was then being processed on him in the United States. The outcome of that decision in 2015 was that the mechanism that allowed the processing of the data of EU citizens in the United States, the US safe harbor mechanism, was found not to be compatible with European data protection law and was struck down. This led in 2016 to the establishment of the EU-US Privacy Shield. At the time, I spoke at many different conferences and said, I will be surprised if the Privacy Shield lasts as long as the safe harbor has just done. The safe harbor had lasted the best part of 15 years. Privacy Shield lasted 4 years. It ended up going in August of 2020, and that was due to slightly different issues. Now it came down to the level of surveillance that the United States tends to carry out with regards to data being processed on its systems, in particular with regards to non-US citizens, meant that in effect it was no longer realistic for the processing of data to be carried out under the Privacy Shield. It was no longer realistic for those organizations to sign up to the Privacy Shield. You could search the register on there that said these corporations, from Nike to Facebook to others, were in effect given an adequacy decision from the European Commission when they signed up to the register, when they signed up to the requirements of that scheme. Yet in effect, these organizations were signing up and saying, yes, we agree to be regulated under the scheme. We agree to adhere to the decisions of the Privacy Shield ombudsperson. We agree not to transfer data to onward third parties, onward jurisdictions, without certain criteria being in place. They signed up to a raft of these conditions. Yet due to the level of surveillance in the United States, really these corporations could not give, while they could sign up and say, yes, we agree to these things in principle, that did not mean that US surveillance systems were not still looking at that data and in effect breaching the rights that those EU citizens enjoy under European law in the EU. Consequently, under the Schrems II decision, we ended up then having the Privacy Shield struck down. But now, as we await possibly a third scheme, who knows what that will be? Are we going to get the privacy umbrella, the privacy anorak, whatever this could be? Who knows? But in the meantime, we really have to ask the question of what is the impact of these decisions? Arguably, we already have a stricter level of data protection and privacy generally through the introduction of GDPR across the European Union than in any other regulated jurisdiction in the world. Very often the question is asked, where is the European Facebook or the European Google? And one of the reasons for this, not just in relation to access to finance, skills, and the unique environment in the United States, but one of the big contributing factors here could indeed be a generally more lax and patchwork approach to data protection and privacy regulation on a state-by-state basis in the United States, with only the umbrella of the 1974 US Privacy Act really offering any protection or any real regulation with regards to how the data of foreign citizens ends up being stored in the United States. So has this greater level of regulation? Great, we have these rights in Europe, but has this potentially stifled innovation that could otherwise have happened? This may already have had a stifling effect with regards to the development of platforms, as already the EU is thinking. Could this mean that in future, the development of things like artificial intelligence, machine learning, blockchain, cryptocurrencies, could these also be inhibited in the EU, partially due to the greater level of regulation? Where should we really be striking the balance? Should we be thinking, yes, it is greater to have these protections and properly pay off the cost of that being potentially less innovation as a result? Is this necessarily a debate that is happening in public so that people can actually consider these issues and make their own choices as a result? Rather than looking to, if anything, make this experience difficult sometimes for the user, should we be doing this in a slightly different way? If you end up going and using a website from an IP address in Europe, in the UK, you will be painfully familiar with the presence of consent bars on websites. You will no doubt be familiar with the fact that sometimes that consent bar has so much text on it and so many buttons, it's the first thing that you end up seeing the minute that you end up accessing a site on your mobile phone or tablet. That consent bar fills a large portion of the screen, sometimes 2/3 of the screen. So you can't actually see the service that you're wanting to access online, because in effect, you're needing to be reminded of your rights and whether you wish to block the gathering of data at the endpoint from you as the user. Instead, should regulation, rather than it being focused on the user and actually sometimes to the detriment of the user, should regulation be looking more at the conduct of the organizations? You could argue that new mechanisms like the Digital Services Act package that has been introduced in draft form by the European Commission, which includes the Digital Markets Act, which defines platforms like Facebook and others as gatekeepers, should this indeed be something that we consider as applying a greater level of regulation, but with regards to how those platforms then act? If we're going to have that level of regulation, should we therefore consider actually rolling back some of the regulation and blocking that we're having for the end user and achieve a greater balance in that regard instead? So let's move on from there and I'll look at some of the issues with regards to social media, mass media, and the way that we are using our news. There are some statistics here provided by Ofcom, the UK communications regulator. The striking thing here is how many people now use social media for their news content, in terms of how they end up being informed of what's happening. And this could be from a range of different sources. Is this just from the written press? Is this from other blogs and posts that people share? And then the comments that they end up making on there. But certainly we can see from changing media habits here that people are choosing to watch news on TV channels far less. Despite the fact, and this is a common misnomer, children here, those say between the ages of 12 and 15, very often turn around. 60% of them say they are very or quite interested in the news. But where are they going to access that news? More than likely it will be online rather than via the format of TV news. And then we start to get concerns with regards to the veracity of the information that might be shared on social media, the concept of fake news, potential misinformation. Let's look at some of the examples around the world. I mean, in the US at the moment, we know that approximately 3/4 of voters who voted Republican in the general election in November are now of the view that that election was not free and fair, that they are under the impression that it was manipulated. Despite the fact there has been no evidence brought before a court that conclusively says this either way, that is the view that has taken hold online. Very often through everything from podcasts to links, to discussions, to blogs, to articles, sometimes from organizations that may look to be verifiable news sources and channels. We have to ask ourselves, are social media platforms becoming a way of sharing information that is not properly verified and not properly sharing news in the way that we would recognize it? These are questions that we are continuing to ask almost on a daily basis. Let's look at some of the issues over the last few years. Many of you may be familiar with Cambridge Analytica and the feeling in recent years that somehow the manipulation and use of data ended up influencing the referendum campaign, the Brexit campaign in the UK, and then the election of Donald Trump in 2016. There have been widespread investigations into this. There was indeed the Mueller inquiry, which ended up saying there were certain issues to look at here, but there was no evidence, or certainly not sufficient evidence, to allow the bringing of charges. Indeed, the accusations that there was widespread collusion between the Trump campaign in 2016 and potentially the US presidential administration and Russia and the leadership in Moscow was heavily inferred for a good 3 years. People were led to believe that this is the reason why President Trump was elected. But after 3 years of investigations, there simply wasn't the evidence there. And indeed, if you read Michael Wolff's book, the first one that he wrote on the Trump administration, it quite quickly becomes apparent that arguably the Trump campaign had an awful lot of difficulty just communicating with the Republican National Committee just up the road, let alone communicating effectively with Russia. So the idea of there being some malevolent influence on the Trump campaign became less and less credible as a result. But there were ongoing investigations into this. I mean, the Cambridge Analytica was the subject of the Great Hack documentary on Netflix that many of you may have seen. This talked about the building of personality profiles, targeting ad strategy. There were issues with regards to the use of 50 million Facebook users' data without their permission, and the inference that Cambridge Analytica had secretly worked on the Leave.eu Brexit campaign. However, the UK Information Commissioner's Office produced a report on the 2nd of October that said they had no evidence that Cambridge Analytica had misused data to influence either the Brexit campaign or that there had been any Russian intervention in any elections. This was after having looked at over 700 terabytes of data seized from Cambridge Analytica's London offices. The UK Investigation Commissioner doesn't generally produce reports or decisions that amount to whitewash. They have been responsible for announcing some of the largest fines under the General Data Protection Regulation. They look very careful at evidence. Where they find evidence of breaches of the General Data Protection Regulation, they have not been shy in applying enforcement. So in this instance, when they're saying they have no evidence, they genuinely have no evidence. It seems that Cambridge Analytica wasn't doing anything particularly unique compared to other political consultancies that regularly help political parties when it comes around to their election campaigns. The biggest issue seems to have been the potential misuse of those 50 million Facebook profile information, pieces of profile information. Arguably, that should have been collected but for academic reasons and ended up being used for commercial purposes. Facebook was fined over £500,000 by the UK Information Commissioner with regards to how that data had been used. And indeed, Cambridge Analytica itself was fined £18,000 for failing to hand over data under an enforcement notice. But there simply wasn't the widespread voter targeting for nefarious purposes that seem to be inferred from some of the documentaries like The Great Hack. Arguably, Cambridge Analytica's influence was an absolute triumph of marketing and snake oil. How powerful ultimately can targeted ads be on voters in terms of actually changing their decisions? Micro-targeting is not a new thing. It was being used in the US presidential administration, in US presidential campaigns in 2012 by both sides, and has continued to be used by the campaigns in the most recent US presidential election. But the actual effect of these micro-targeting adverts, when tens of millions of dollars have been spent by political campaigns over the previous 2 years, very often the actual effect of those targeted adverts is pretty minimal when compared with similar exercises that were carried out on Facebook as part of academic studies when they looked at whether adverts actually changed people's propensities to buy a product. And very often the response was, no, it doesn't actually change an individual's purchasing preferences, and in terms of changing people's voting preference, that it also is very often very difficult to discern. There is no doubt that Cambridge Analytica was engaged in nefarious tactics. You only have to listen to the recording that was carried out of the Cambridge Analytica CEO, where he was bugged in a restaurant discussing various things, various nefarious activity that could be undertaken if requested, anything from blackmail to bribery to some quite underhand methods. But the widespread manipulation of data wasn't one of them. So in conclusion, really it's actually important to start thinking about where are we now? George Orwell, 1984, there's the quote. There was, of course, no way of knowing whether you were being watched at any given moment. Through all of our manipulation in terms of what we end up looking on online in terms of social media, to then when we go outside and we're recorded on CCTV, to the way that when we use public transport, our activities, the tickets we purchase, the places that we travel to are watched, as well as if you go on the roads, you've got automatic number plate recognition cameras, not just if you're going into city centres, not just if you're going into areas with a congestion charge. Any motorway, any major road in the UK is covered by automatic number plate recognition. So you're being watched very often wherever you may be at any given moment, and you won't actually be familiar with the fact that you are being recorded. It is just happening on a very regular basis. Where do we go from here? Arguably, sometimes, despite all of this data, despite all of these different news sources, we aren't necessarily getting the reporting that we might otherwise want. Sometimes our news and our views can be very insular. No bigger example than that is probably when it comes to COVID. At the moment, I can't think of many people in the UK who are looking an awful long way beyond the 21st of June, when in theory, all of the restrictions that we currently live under will be rolled back. Though whether that means that we might end up with tiers again after that, whether we might still have limitations on travel, in particular abroad, whether there might be limitations in terms of Whether we can still get within a few meters of each other, that has still not really been confirmed. But we aren't really looking any further ahead of that. Yet there are some really concerning things happening in the world. We have potentially in China large numbers of people being detained in new camps that are being identified. Also in China, they've said that homosexuality could be called a mental disorder. Meanwhile, we have a famine in Yemen that hasn't really had the coverage that it deserves. But these things are not really receiving much in the way of attention. And arguably they should be. Arguably, we should be using this technology to talk about these major issues around the world, to be aware of them, and to start thinking about how we are going to respond and react to them, rather than instead looking and being so insular and only looking at the development of restrictions in our own countries and our own country's economic prospects in the short-term future. We're talking about long-term geopolitical things here that we should be really having greater influence on in order to shape the world of the future. There's my contact information, ladies and gentlemen. I hope you found that whistle-stop tour through privacy and then some reflections on the development of data protection and indeed its application in the future helpful. Please do feel free to contact me online. Feel free to find me on Twitter. Let me know what you thought about the discussion today. And indeed, if you've got any comments with regards to the conference as a whole. But thank you very much indeed for listening. I hope you found that enlightening and entertaining, and I hope you enjoy the rest of the conference. Thank you very much indeed.